Osiel, who's sitting here, is a prolific and world-renowned scholar of legal responses to mass atrocity. He received his BA from the University of California, Berkeley, his MA from the University of Chicago, and his JD and PhD from Harvard University. Professor Osiel is the author of no less than 7 books, including the now classic, a contemporary classic, Mass Atrocity, Collective Memory in the Law. And his articles have appeared in the Harvard Law Review, Columbia Law Review, Law and Social Inquiry, Human Rights Quarterly, and Opinion Juris, among others.
Pleasure and honor to be here, of course, and thank you for the organizers for inviting me. Let me first summarize just a bit of the book that I wrote a long time ago that most people don't know all the other stuff I've done since. Basically, I spent 6 months in Argentina when I was a law student right after law school, observing and being drawn into the prosecution of the military juntas there for the death of some 30,000 people in the dirty war of the 70s. And getting to know and befriending several of the prosecutors and government attorneys, I came to know what they were really trying to do in this prosecution. And what they wanted to do was very different from what criminal prosecutors normally want to do. Prosecution criminally is normally about 3 things: retribution, deterrence, and rehabilitation. Well, no one really imagined rehabilitating Jorge Vidal, the top general of the first junta. These people were too deeply committed to what they were doing to this national security ideology, which had induced them to order the executions, murders of so many people. Deterrence didn't work, because the idea is that, well, people who run the state, who control the guns, can't really be deterred by the threat of prosecution thereafter. They will either live to their... Am I making these slides?
Yes, I think maybe once you touch the microphone to the name tag,
okay.
rubs against your lapel.
All right. Okay, let's hope that's better. All right, so rehabilitation doesn't work. Deterrence doesn't work either, because the people who have the guns are not likely to give them up, and either they will retire into comfort, or they will die in a blaze of bullets, being overthrown by someone else. And today, that would mean humanitarian intervention of some sort. Okay, that leaves retribution. Normally, retribution means that people have violated the fundamental moral principles of their society and their political order, and so they're held accountable. They deserve punishment because they breached these fundamental social norms. But in a regime, a totalitarian or authoritarian regime that imposes its own ideology upon people, the norms themselves are transformed in ways that makes that not directly meaningful. Okay, so that leaves really nothing in the way of traditional rationales for prosecution at all. So, well, we can't let these people not be prosecuted. Surely there must be some reason, some basis for doing so. And so what they came up with was this notion of influencing the collective memory of what had happened as a goal for criminal prosecution, which meant basically transforming the way that Argentine citizens thought about their recent past through the prosecution and the way in which the prosecution was conducted. So I formulate my argument in the way of a response to skepticisms about that proposition or hypothesis, that can be done and should be done. So first source of skepticism is the concern that this approach would sacrifice the defendant's rights out of a concern with the didactic purposes of enhancing social solidarity around these new liberal values that are being restored, or you might even say created within a society that knew very little of it. That's a problem. For instance, the breadth of the evidence that's introduced can implicate a defendant in criminal acts for which he's not really responsible. He didn't have any immediate, discernible, plausible connection to the events of the particular criminal acts. The second reason is that criminal trials can distort public understanding of events by focusing on issues that are maybe central to the law, but superfluous from any other point of view. Perhaps a more important point of view from the perspective of influencing public memory. And so over time, people realize that truth commissions do a better job of telling the broader story of what happened throughout the country without having to pinpoint criminal liability on any individual for any particular act.
That's not the problem.
That's not the problem.
Let's take it out of the Just kidding.
Okay.
Try to help.
Sorry for the distractions of that noise. Okay, so the third concern, the third source of skepticism, is trials have led some people to invoke the memory of the past as a template for understanding everything about the present and the future as a kind of wholesale program of politics, and that's clearly an abuse of memory. I give some examples of that in the book. Fourth, trials tend to do either one of two things, both bad. First, they can implicate so many people in the events that it's impossible for people to actually admit guilt and repent for this because it's simply asking too much of too many people. But the alternative is to avoid that by narrowing the scope of responsibility and those who are currently prosecuted to so small a group that everyone else is more than happy to blame them for what happened, but in ways that are, again, historically inaccurate. Far more people were implicated, often quite directly in the crimes than those who can be prosecuted. So fifth, another problem is that maybe collective memory is a process that just can't be much influenced in intentional ways. It's a kind of essentially a byproduct by its very nature. It can't be manipulated. It grows spontaneously in its own way, and who knows how. But at very least, the law can't do much to influence it. And there's evidence of that. That is to say, just to stay with the Argentine example, that the efforts to influence the way people remembered the Dirty War era as through these prosecutions as one of state terror and personal insecurity just didn't convince many Argentines, to judge from what anthropologists have found going into neighborhoods and talking to people who tend to remember that as a period of public order and stability, relieved from the prior Peronist era of terror and insecurity. Sixth, even if collective memory can be deliberately influenced and shaped to some degree through law, maybe it's not, it can be done effectively only if it's done through smoke and mirrors backstage. In other words, the prosecutors in the state don't disclose what they're actually trying to do. Even if they could do that, that is, even if they could keep it secret, not disclose what they're actually trying to do, that may be indefensible because in a liberal society, things are supposed to be more transparent. You're not supposed to keep backstage the fact that you acknowledge that none of the usual purposes for criminal prosecution apply and sort of invent this new one. What's interesting about that, I find especially, is that there are many ways to tell the same story of the Dirty War. You can concentrate on this set of victims, that set of victims, this set of perpetrators, that larger category of perpetrators. And depending on how you define the victim group or the perpetrator group, you tell a very different story with rather different implications about what the country should learn from this from the point of view of its public memory. That's inherently so. There's no way around that. It's just you have to make some choices, and they have implications. Now, since my book, a couple other reasons for skepticism have become prominent in mind. First, dramaturgy is no monopoly of the prosecution. Milosevic used it rather effectively, some would say, and that although I suggest that prosecutors try to turn these trials into morality plays, good and evil, they also threaten to become theaters of the absurd, as one critic of my book observed, a kind of farce, so that the defendants can successfully delegitimate the entire procedures by showing how they're very selective and focusing on certain wrongdoers and not others, especially in a war when one side gets prosecuted and the other doesn't. Now, with that said, let me just, since this conference is partly about how to represent mass atrocity, let me show how some of the issues that present themselves. I'm doing some consulting to the Pentagon now on prosecuting terrorist leaders in Guantanamo, and some of the same issues arise in determining who are the group of perpetrators and victims, whether you're talking about genocide or terrorism. A lot of people who are implicated in different ways. How does the law choose to represent these different kinds of atrocities? There are varieties of ways. Start with order. In some ways, this is the easiest if you had a written order communicated from someone at the top to someone at the bottom, and that person then victimizes someone. Okay? You have a record. Well, that doesn't usually work because people are wise enough to destroy the records, usually. And even when there is a record, it's cast in euphemism, what the order was. The euphemism lets the superior say, I didn't order genocide, I ordered resettlement. And the subordinate says, I didn't know when I was resettling or moving these people from X to Y, in fact, they would thereafter be killed. I was just severed. So this, for a variety of reasons, this doesn't work too well. Second alternative is what's called command responsibility. So there's a formal chain of command between this guy and this guy. And on the basis of that chain of command, it creates effective control of A over B, which means that even if there's no order, A could have prevented B from, harming C. Had the capacity to do so, didn't exercise it. Capacity or responsibility of his position was to prevent that crime from occurring, so he was held responsible under this. Well, with terrorism in particular, the prosecutions I'm working, there's no chain of command between Khalid Sheikh Mohammed and the guys who hijacked those planes. So that doesn't work. Then we're all left with aiding and abetting, which means that A made some significant contribution to B. Well, that's not good enough to get the death penalty, at the very least, because aiding and abetting is regarded as a form of, makes this person an accessory. This is the perpetrator, the real bad guy, and this guy just knowingly contributed. Because he hasn't intentionally caused the harm of B to C, the death penalty wouldn't follow. In other words, his mental state, his mens rea of knowing what will happen, but not intending it. That's not blameworthy enough for the most severe criminal sanction. So understandably, the defense counsel is arguing that if their defendants are guilty, it's merely as aiding and abetting. Okay, so that leaves the issue I'm focusing on, what's called joint criminal enterprise. The notion is that you don't look dyadically at the relations of individuals to individuals. You represent the process in terms more holistically. So all these people share a common purpose of killing Americans or attacking American civilian installations, which is a war crime. Civilians and civilian property. They all share that purpose. That purpose defines them as members of this enterprise within the bounds of this circle. Anyone who's a member of that enterprise who contributes to it through some intentional act in any way, knowing that there are other people within the enterprise, becomes liable for the criminal acts of every other member. So all these people contribute to harming civilians in the World Trade Center in some way. Or they contribute, they provide the financing, they provide the training, they provide the airline tickets, whatever. And so any member of this group, just focus on this guy, becomes liable for the wrongs of anyone else in the group in virtue of the common purpose. The Nuremberg Tribunal relied on this idea. Control Council Law Number 10 incorporates the notion of common purpose. It gets reformulated by the ICTY, ICTR in terms of joint criminal enterprise, but the concept is the same. The terminology is a little different. So whether we're dealing with genocide or terrorism, we encounter the same fundamental problem. Should we understand the process in terms of what in the morning we call the very individualistic assessment, looking dyadically at the relation of individuals to one another, and particular contribution of each to the next, or can we conceive the whole process in more collective terms, if you will, even if the collectivity has no formal organizational bounds, it's hard to say exactly who's in and who's out within the circle and out exterior. And yet, we probably feel that this dyadic approach doesn't quite do justice to the collective nature of the wrong. But how do we then collectivize our understanding of the wrong and yet do justice to the principle of individual culpability, that people can only be held accountable for what they're really responsible for? That's the problem. So, and of course, just to finish, I know my time is essentially up. If that weren't difficult enough, you also have to deal with how to conceptualize the victim group. In the Genocide Convention, there speaks of protected groups, and we enumerated some of those this morning, dealing with what kinds of groups are included and what aren't. But even then, you have the question, well, are you talking about Bosnian Serbs within this village, where the protecting group? Is it within this whole region? So again, that if through JCE somebody is accountable for the wrongs done by others, does that mean the wrongs done to, well, what was the protected group exactly? Or is it, in the case of the Milosevic indictment, 3 different regions over a vast number of years? Same with crimes against humanity, where the group is now defined in terms of the civilian population, rather than that racial or religious group. But the issue is still the same. So whether we're talking about perpetrators or I should say participants or victims, we face essentially the same question of how to represent mass atrocity at either level. I don't purport to have any answers, but those are questions we're all thinking about.
I very much appreciate Mark's comment that the almost utopian hopes that some people invest in trials writing history are very problematic hopes. That to steer cultural processes is very difficult, and to arrange a trial with the perspective that a very specific version of history will one day settle in the public mind, in the collective memory, I think we ought to be highly skeptical about that. At the same time, here too, I would not want to throw the baby out with the bathwater, because I think we have to take seriously at least the possibility that trials will leave traces in the public conscience, in the collective memory, and it is an interesting theoretical and empirical enterprise to identify those traces, to understand the mechanisms through which trials, once mediated, eventually settled in the, or their stories settled in the public mind. During the Vietnam War, we were able to identify there were very different narratives constructed afterwards. There was a journalistic narrative, and Seymour Hersh won the Pulitzer Prize for his book, Only Lie. There was an administrative commission narrative. There was, under General Pierce, a commission that investigated this. And then there was the criminal trial in the courts-martial against the perpetrators. We did a content analysis of 120 or so American history textbooks. And it was fascinating to see that the history told in the textbooks is a mirror image of the history of the narrative produced in the criminal trial. Not of the, in terms of the perpetrators who are named, it's the one who was convicted, Lieutenant Kelly, who appears in the textbooks. In terms of the number of victims, it's the number that were underlying the charges, a little bit above 100, not the possibly more than 475 that appears in the sites. In a number of ways it is the, and we can think about the logic of why is it that textbook publishers and those who write for the publishers of textbooks adapt the legal narrative. I think it has a lot to do with the enormous legitimacy of the legal process with its procedural safeguard garners more legitimacy than the journalist, more legitimacy than an administrative commission that works somewhere behind the curtain. So I would say yes, legal proceedings against perpetrators of grave human rights violations leave traces in the collective memory, but we need to understand the logic, and the traces may not be those that the originators of trials intended.
Yeah. Devin said that there's a law has, rulings of course have a certain prima facie authority, as you put it, so that even if people disagree with the court's judgment, it still influences in some way, which we can't, I think, methodologically or easily determine how they think about the events. And Darky mentions that it was the legal results of the May Lie prosecution, not Cy Hirsch's book or the Pierce Commission report that became the basis for the way in which memory of these events were transmitted in the textbook. You know, it's really, in this country, that's gives peculiar legitimacy to courts in ways that very few others do. So to assume that there's a prima facie authority the courts have in the public mind, it simply is not, unfortunately, or for better or worse, not true in much of the world, where there's no reason to have the kind of give the kind of credibility that we Americans give to the courts. And certainly when I've seen reactions, counter reactions to my first book around the world, like Peter talks about, people say, well, that's true of America, but there's no way in which anyone would think that in our country what courts do profoundly influence the way people think about those events. And so I think that bears on your observation. It explains why textbooks have adopted the legal rather than the journalistic or investigatory accounts of the language.